Colorado diminished value laws.
Diminished value is the lost economic or market value of your car as a result of having been in a car accident. Even if your car is 100% repaired to its pre-collision state, future potential buyers will value your auto as worth less than the same motor vehicle with no accident history. With the rise of Carfax and other car history report services, used car buyers can easily determine whether your car has been in a crash. Diminished value, sometimes called diminution of value, is a type of economic damage you can recover as compensation from an at-fault driver or their car insurance company under Colorado law. What is diminished value? Diminished value, sometimes referred to as DV, is a term used to describe the decrease in a vehicle's market worth following its involvement in an accident and subsequent repair. Essentially, diminished value takes into account the notion that a previously damaged and repaired vehicle is deemed less valuable than an equivalent vehicle with an untarnished accident-free history. Several factors contribute to the determination of diminished value, making it a complex and multifaceted concept. Newer vehicles that have sustained substantial damage and undergone subpar repairs are more likely to experience higher levels of depreciation. The age of the vehicle is a key factor, as newer cars often suffer more substantial depreciation since they are perceived as having a longer future ahead. The severity of the accident also plays a pivotal role in determining diminished value. Moreover, the quality of the repairs is a crucial aspect influencing diminished value. A professionally executed repair job that fully restores the vehicle to its pre-accident condition is more likely to mitigate diminished value. However, shoddy or incomplete repairs can exacerbate the perceived decrease in value, as potential buyers may harbor concerns about the long-term integrity and safety of the vehicle. What is a diminished value claim after a car accident? Colorado follows the fault law system, which makes the negligent driver liable for damages. If the car is repaired, you may pursue compensation for the lost market value of your vehicle from the insurance company as part of your property damage claim. A diminished value claim works like other liability insurance claims after a car accident. You must present your Colorado diminished value claim to the insurance company. The adjuster will propose a settlement offer and you may negotiate the claim. If you cannot agree upon a value to settle your claim, then you must decide whether to accept the last offer on the table or file a lawsuit. What types of diminished value claims can I pursue in Colorado? Immediate diminished value. This refers to the difference in value between your vehicle before the accident and its current value, prior to any repairs being undertaken. Inherent diminished value. Even after repairs are completed, the fact that the vehicle has been in an accident can lead to inherent diminished value. Prospective buyers perceive the vehicle as less valuable due to its accident history. Repair-related diminished value. If repairs are improperly executed, the vehicle's value may diminish due to problematic, incomplete, or low-quality repairs. What is Colorado diminished value law? The state recognizes this form of loss as a compensable harm inflicted by the negligent driver. Under Colorado law, you may pursue a claim for all three types of DV as applicable to your circumstances. Diminished value claims for motor vehicle collisions dates back to the advent of the automobile. The Colorado Supreme Court confirmed this category of damage 100 years ago in Larson v. Long, 74 Colo. 152, 1923. The measure of damage is the difference between its value immediately before its damage and immediately thereafter, together with any expense of reasonable efforts to preserve or restore it. Colorado, like most states, does not have a diminished value statute. Some states use specific formulas to calculate diminished value amounts. The most well-known court-issued formula is 17C, which comes from a Georgia Supreme Court decision in Mabry v. State Farm. Although insurance companies in Colorado may use the 17C formula internally, it is not binding on a claim in Colorado. In Colorado, it is up to the claimant to present an amount of DV supported by evidence and a reasonable calculation method. Third-party versus first-party DV claims under Colorado law. One restriction that exists in Colorado diminished value law is that you can only pursue a claim against a liable third party. A third-party claim is a claim against another party who caused your damages. A first-party claim is a claim against your insurance policy for harm you inflicted upon yourself or lacks a liable third party. For example, if you cause a collision, You cannot pursue a DV claim against yourself or your first-party insurance coverage like collision or comprehensive coverage. How long do I have to pursue a diminished value claim in Colorado? In Colorado, you can pursue DV for the same length of time as any other compensable damages. In other words, your deadline for a DV claim is the statute of limitations for your car accident. For a car accident, you have 3 years from the date of the collision to pursue a claim. If you do not resolve your insurance claim or file a lawsuit before the statute of limitations expires, you lose your legal right to pursue compensation for diminished value. What are my legal options if the insurance company denies my claim or refuses to make a reasonable offer? Insurance companies are often hostile to diminished value claims. It is common for them to ignore the claim and hope you give up without paying anything. They also tend to deeply undervalue these claims if they will make an offer at all. If you do not reach a fair settlement with the insurance company, you have 3 options under Colorado diminished value law. Accept the adjuster's last offer and settle the claim. Present more evidence to support your claim and ask the adjuster to reevaluate. File a lawsuit. Often people receive low offers from the adjuster because they do not present any evidence supporting their diminished value claim. Adjusters rarely take claims seriously in these circumstances. Obtaining a diminished value appraisal from an independent appraiser is an option to present evidence to support the value of your claim. If you present evidence to support your demand and the adjuster does not provide a satisfactory offer, your alternative is a lawsuit. Most diminished value claims fall within the monetary limit of the small claims courts in Colorado. You will need to present evidence of the value of your claim at trial. Note that if you also have a bodily injury claim, you should talk to a personal injury lawyer before filing a lawsuit to avoid creating complications for both claims. If you have a high-value automobile, your claim may exceed the limits of small claims court.